There will be a delayed broadcast of this meeting on Parliament Channel 1 and Parliament Radio 105.5 FM. The meeting, however, is being broadcast live on Parliament's YouTube channel, ParlView. My name is Clarence Rambarat. I'm the chairman of this committee. I now invite the other members of the committee, my colleagues from the Senate, to introduce themselves.
Good morning, everyone. Renuka Sagram Singh Suklal, member.
Good morning, everyone. I am Randall Mitchell, member.
Good morning. I'm Jayanti Lachmanial, member.
Good morning. I'm Paul Richards, member.
Thank you very much. We have 6 groups before us today, and I wanted to invite those groups to introduce the representatives who are with us, and we would proceed in this order: the Law Association, the Trinidad and Tobago Promoters Association, the Media Association, the Caribbean Center for Human Rights, the Center for Nonviolence Research and Development, and Feminitt Caribbean. Thank you.
May it please you, Chairman. I am Ravi Rajkumar. I appear on behalf of the Law Association led by Mr. Douglas Mendez, Senior Counsel. I apologize for the absence of the President, Ms. Sophia Choate, Senior Counsel. She had an emergency this morning and cannot attend the meeting.
Okay, thank you.
Good morning, everyone. I am Jerome Persia, the President of the Trinidad and Tobago Promoters Association, and I'm also joined by my colleague, Mr. Colin Miles, who is the Secretary of our board.
Thank you. Media Association. The Caribbean Center for Human Rights. The Center for Nonviolence Research and Development.
Good morning, Mr. Chairman. My name is Shona Alexander Benjamin, and today I'm joined by Masuda Muhammad Batiste, our Council and Community Liaison Officer. The other member of my team is Ms. Dalarine Liverpool Young. I would like to apologize. She's our lead attorney. I would like to apologize for her absence due to an unforeseen matter.
Okay, thank you very much. And Feminitt Caribbean, sorry.
Hi, good morning, everyone. I'm Ashley Burnett, founder and managing director of Feminitt Caribbean, and I'm joined by Anna McEwan, one of our core members.
Okay, thank you. So we expect to be joined by the Media Association and Caribbean Center for Human Rights. At this time, I would ask that I would invite member Lachmi Dial to lead us off in respect of the submission from the Law Association. Thank you.
Good morning. Good morning, Senior. Good morning, Mr. Rajkumar. Thank you all very much for joining us, and thank you so much for the comments that were provided. Very helpful. I'll start off by saying that a lot of common ground is covered in many of these submissions, and that has to do with things that you all have covered, the exculpatory sections. But I want to solicit your views on things that would have come up with other entities. Firstly, the Law Association made reference to the chapeau of the sections where they create the exemptions, and you recommended use of the words that a change in the wording. So let's say, for example, in section 22A3, that it says a person does not commit an offense under this section if the conduct that is alleged to constitute the actus reus of the offense is, and then we go on to list the number of things there. Sorry, I'm hearing somebody speaking. I'm not sure if it's, yeah, okay, all right, yeah. Let me tell specifically, when we go down the list there, if you go to subsection C, subclause C, with security monitoring. We've raised this issue of the security monitoring and whether a person, and how do we draw the balance between people having the entitlement to monitor their home and, of course, invading the privacy of someone who's a guest at their home. Would you say that it's necessary for us to change the section, even though the definition, let's say, of voyeurism really specifies that the purpose, you must prove that the purpose is linked to either sexual gratification, humiliation, or distress? Is it still necessary, you think, to refine the wording of this exculpatory clause in order to ensure that someone who is genuinely security monitoring isn't captured by the offense?
That's a good question, of course, and it's I suppose it's answered by the appropriate drafting technique that is used. Our concern, as we had expressed it, is that the provision might create ambiguity to the extent that the chapeau is saying that where they. I'm sorry, as I'm speaking, I'm trying to scroll to the particular provision.
Sure.
The chapeau, as we refer to it, is speaking of the offense of voyeurism is committed if the purpose for obtaining sexual gratification for himself and so on, he knowingly does those things. And then when you get to the section immediately after, it says, person does not commit an offense under this section if the acts that are alleged to constitute the offense are, and then they listed. So that we are concerned that if you don't limit it to the conduct itself as opposed to the reason why you are doing it, that you might create an ambiguity at the very least. At the worst, it would be somebody will say, well, listen, this is exactly what I was doing. I was, these cameras are there for the protection of my home, or the police officer might say, I was looking at these photographs, or I was looking at the video footage in carrying out my duty. But then at some point in time, it morphs from what might be legitimate into something that might not be legitimate. And we lawyers will then have to, and the court will then be left with the task of trying to resolve exactly what the Parliament's intention was in those circumstances. So the point that we are making is make it clear. It may be that the technique we are suggesting does not make it clear enough, but we are saying that you need to make it clear because we are seeing an ambiguity.
Right. Senior, the thing about the wording suggested is if we say that there's a blanket, no charges laid if the act committed is committed under these circumstances, then we are almost not looking at all to the intention. If I have performed one of these acts, whether I am law enforcement or so on, or let's say security monitoring, I use the term nanny cams on the last occasion, and I think we all know what that is. So you have a nanny cam, and if I as a homeowner raise this issue and say that I have a nanny cam installed, does that automatically give me a defense and a reason for me to not be charged when, you know, law enforcement then would not go on to look at the purpose for which it may have been used and other things? Because I don't, what I'm looking at, the mischief that I'm looking at here is where someone is able to raise that defense of security monitoring, yet they have committed the act, albeit in pursuance of security monitoring, but they have done it for humiliation or distress. So let's say, for example, they have then shown it, shown the video to somebody else, shared it in some way. I mean, that may be captured by other clauses and so on, but it's that voyeuristic act was not solely for security monitoring. There was an underlying purpose. As you say, it morphed into something differently. We have other things like people being visitors to your home where security cameras are located. Can an intention be inferred from those things? can you not infer some sort of negative intention from someone installing a security camera in what should really be a very private area of your home and where you invite your guests, so like a bathroom, for example. Those are some of the concerns that we have raised before. So what's your view on perhaps creating a section or creating some sort of exemption where you cannot raise security monitoring if it is that the camera is located in an area that ought to be very private? I don't know if you are aware, or I'm sure everyone has seen it in change rooms in large department stores in the United States, where they install stickers in their change rooms to say that it's monitored by same-sex persons and so on for the purpose of, theft and all of that. Do you think we need to go so far here to prevent people from, or to have the public being aware of what is taking place and that they're being video monitored in public spaces which you have an expectation of privacy, like a change room, and to prevent, let's say, a store owner or something from being charged with a voyeuristic act?
I'm going to say a couple of things and then I'll ask Ravi if he wants to jump in, because of course he's the more experienced criminal lawyer among the group. First of all, it seems that that you are not in disagreement with our position that it needs to make clear, it has to be made clear in the law that you can't start off doing something legitimate and then end by doing something that is not intended to be lawful by the act. However that is achieved, we are really not concerned. It is you have parliamentary counsel and you have draftsmen who I am sure who are attached to the parliament who will be able to assist you in finding the correct language to do it. That in itself, as we all know, is a specialty. I don't claim to have any specialization in drafting legislation. So whatever technique is used to achieve that, we are quite happy with. On the question of security cameras in otherwise private areas, the problem there is that it may be precisely because those are private areas that somebody might seek to use it to commit a crime. So stash away something in their clothes, or I don't know what else they may seek to do in a bathroom in somebody's home, in a department store, or something else. So I don't think that it would be helpful to exempt this like that altogether. But once again, the issue is starting off with legitimate surveillance and ending up with committing an act that the bill intends to prohibit. And as I say, we are happy with any drafting technique that is used to achieve that goal. I don't know if Mr. Rajkumar has anything to add to what I said.
Senior, just to simply say there is a difference between public and private. And again, I agree that you have to look at the drafting technique. I think that Mr. Rajkumar is quite correct in saying that in public areas, I think there should be signs displayed, and that should perhaps be part of the legislation in like changing rooms and public bathrooms, etc. There must be some sort of warning put into place. I would have no difficulty with that. But I do agree that with what you say, there's a difference between public and private. And I also agree that it is a matter of the technique in ensuring that there's certainty with regard to the penal, where there's a penal clause like this. So subject to that, unless I could assist the committee any further, that's the only comment I would make.
Okay, thank you. Thank you very much so far. Let me just ask if there are other members who have questions for the Law Association.
Yes, Chair, if I could.
Right, go ahead.
Good morning, everyone. Again, thanks for joining us. Would the Law Association be able to comment on whether or not a further differentiation should be made in terms of public versus private spaces, where in some areas there is a differentiation maybe between a commercial space that the public has access to, as opposed to a privately owned space that a person may or may not be present in and may end up being caught by video cameras or recordings or photographic camera that may eventually be used for nefarious purposes? Should there be some sort of differentiation made between, a further differentiation, made between those sorts of spaces and the expectation, as Mr. Rajkumar said, is they are well-held understandings or legal definitions of public versus private spaces. But in the context of this amendment bill, do you think there needs to be a further delineation of some of those and the expectations for the purposes of this voyeurism bill?
It doesn't occur to me offhand. I mean, we have been speaking about cameras in a private home. I don't know if anybody really puts the cameras in their bathrooms in their private home in any event. I suppose we're just sort of imagining the worst case scenario, as it were, try and test the legal proposition. But the cameras that people have in their home are usually outside. Of course, as Mr. Lakshmi pointed out, you may have the nanny cameras where you install to I suppose maybe some people might monitor the persons who come into their home to work, and to a certain extent that is also legitimate. So I can't see that there is
But in addition to the bathroom, for example, one of the scenarios that was raised was a scenario where a nanny or a helper was in the home, and the camera may not be in the bathroom, it may be in the bedroom. Do you think the law should provide for the person to indicate to that employee, as it were, or guest, that these premises are monitored so that they're aware? So if they go into an area, there's an expectation that, well, I may be filmed and X, Y, and Z may be the case.
Well, I think that is given. I didn't realize that is what you were focusing on when you ask if there's a difference between the two. Clearly, if anyone comes into your home and they're going into a place where they can expect privacy, then they ought to be informed that there's a camera in there and they may be monitored. As I say, I can't imagine anyone having a camera in their bathroom and their guests go in there and say, "Here now, our cameras are on, so watch what you're doing. Well, what else are you going to be doing in a bathroom? A guest is going to be doing in a bathroom." So as I'm saying, is we sort of imagining a situation probably doesn't arise, except for where the nanny camera situation, as Mr. Lakshmi was pointing out. But yes, to your question, which is, should there be a warning? I think clearly there must be. If people must know that they're being monitored, so that.
So do you think the law should provide for that in a provision or something?
I certainly think so, yeah.
Thank you.
Chair.
Yeah, thank you. Before we move on, I just want to invite the representatives from Caribbean Center for Human Rights and then the Media Association to introduce themselves.
Okay, I just was trying to unmute. The one comment that I would like to make in reference to the point that has just been discussed is that if it is a matter of whether it is going to be regarded as illegal under the law, I think that the distinction should be made as to whether or not the pictures being taken or the videos being taken are going to be shared or shown to somebody else. Like other members of this committee, I cannot imagine people in their own private homes having cameras in their bathrooms. It's a really present and difficult psychological problem with somebody whom they expect to be using it. But I do know that I have had cases in terms of shoplifting where in public spaces where shoplifters, and in one case it was people who worked in the company, put company goods into a bag, and she went into the ladies' toilets and hid it behind the bin, which is normally used for sanitary napkins. and then at checkout time, went to check out of the company and then went back in and said to the guard, I just have to go to the ladies, and went to pick up the bag of stolen goods. So I can see a logical reason outside of domestic violence to have those cameras in changing rooms and bathrooms in public spaces. But I don't really, and I do agree that there should be a notification. So people should know that they are being monitored. But I think that unless there is actual proof that it's going to be used or has been shared by other people, one doesn't need it in your own home.
Right. Okay. Thank you very much. What I would do next, I would ask the Media Association to introduce themselves, and when they do, I would invite them to speak on this particular issue, security monitoring, and then we'd get back to the rest of their submission. Then I'll invite the representative of the Center for Nonviolence Research and Development to speak on this issue of security monitoring. And after that, I'd invite the representative from Feminitt Caribbean to speak on this issue of security monitoring, because you've all made submissions on this particular issue, and we could take your viewpoint at this stage. So Media Association, followed by Center for Nonviolence Research and Development, and then Feminitt Caribbean. Thank you.
Thank you very much. I'm sorry I'm a little bit late. I'm Ira Mathur. I'm the president of the Media Association. We've had a good look at the amendments. Also, got the help of several attorneys. And yes, regarding the whole question of security monitoring, and forgive me if I'm squinting, I've just been to the eye doctor and my eyes have been dilated. So I just, I think I'm not quite sure what security monitoring means in this context. And I'm wondering whether it should be linked in connection with legal proceedings. So my question here is that, can anyone simply claim that he or she is monitoring premises and is therefore does not breach the law? I've noted the defense for the purpose of obtaining sexual gratification for himself or another person, or causing humiliation or distress to a person knowingly. The question here for me is that, how does a prosecution going to prove that the intention of a defendant? Should the onus be on the defendant to prove that he or she did not have such an intention? So those are my thoughts around security monitoring and my questions.
Thank you very much. Center for Nonviolence Research and Development on security monitoring.
Good morning. I agree with some of the points that was made in reference to informing persons that they are being monitored when they enter a private residence that have cameras. I would also like to say, because we may not be able to conceive a crime does not mean that there are individuals within our society who may commit such a crime. And from my experience, we have had cases where husbands have monitored and partners have monitored their partners within what we term private spaces like bathrooms and restrooms within the home. So thereby, I think that some type of amendment can be added to protect first the person who owns the home, and also to protect those who are coming within the home, because our public policies ought to be preventative in nature. So it's preventing someone from breaking the law and preventing someone from being harmed. Thank you.
Thank you very much. And Feminitt Caribbean on the issue of security monitoring.
Good morning, everyone. We definitely agree with the points that were raised before, but I do have a question concerning, okay, so there is a notification when you go into bathrooms that you are being monitored, but that does not inherently give consent. And so even if you are aware and you go into these rooms to change, knowing that you're being filmed, it doesn't consent to what happens to that footage after. So how can we possibly deal with that if an issue arises with that? So that's my comment on what was raised.
Okay, your comment has been noted. I want to go back to Member Lakshmi Diyal in relation to the submission of the Law Association.
Yes, thank you, Chair. It's linked back to this. My next question is linked to the same exculpatory section, because I noticed the Law Association raised the issue as well of people filming an estranged spouse or partner. And I had raised in my contribution where there's an exemption that the acts that the person reasonably believe were necessary for legal proceedings, whether legal proceedings include family law, divorce proceedings, and so on. I know neither of you, Senior or Mr. Rajkumar, perhaps have practiced widely in family law court, but I've seen enough to know that people are now relying heavily on video footage, WhatsApp chats, all sorts of things, electronic forms of, surveillance and media and so on in their divorce proceedings. Do you feel that it's, that this is too wide a section in terms of giving someone leeway or a reason to perform, to conduct video surveillance and so on? If it extends to family law proceedings, can it open up the floodgates of persons committing all sorts of intrusions of privacy for the sake of legal proceedings and being, having a legitimate defense here? Someone just mentioned about people filming their partners and so on. Let's say, for example, people think that there's an act of infidelity and they install cameras and they say then that I'm doing this for the purpose of my divorce that I intend to file for later on down the road. Can you foresee a difficulty arising here with that part of the clause?
Sorry, Jayanti, I came in just after you started speaking. I was
okay. Right. So very briefly, Senior, let me just say this very briefly: legal proceedings and whether they include divorce proceedings, family law proceedings, and whether creating a defense there for legal proceedings can then allow persons to film and commit acts to capture, let's say, infidelity and so on, which could be linked to humiliation and distress, but they are raising a defense that it's necessary for legal proceedings because they subsequently want to file for divorce or something like that along those lines. Is legal proceedings too wide in terms of, we're looking at, let's say, subclause D2? Do we need to refine legal proceedings?
I see what you mean, yeah. I think that I will have to, as they say, take that on advisement, simply because I think, as I recall, maybe Mr. Rajkumar might be able to give you an answer off the top of his head, but I think that there would already be rules governing the admissibility of things like tape recording and therefore video recordings that are not taken without consent. I think that there may be already rules governing the admissibility of those documents in court. So I certainly would want to refresh my memory about that before relating it to this particular provision. I don't know if Mr. Rajkumar would be able to provide a ready answer.
The law, as the section is very wide, Jayanti. Legal proceedings, and I'll go further, or the administration of justice, I think would mean that any type of videos could be admissible subject to the rules of evidence. As it stands now, a video evidence is admissible once you could relate it to the relevancy of the matter. Perhaps we could look at it a little closely, because at the end of the day, it could be made, it could be used in legal proceedings as it stands right now. I mean, I haven't thought beyond that. And again, I could probably look and send a note off again to you, if I look at it overnight or something. So, but it is admissible at this stage, and it will affect family proceedings.
Yeah, so we'd be happy to hear from you all on that, on whether you think that, because barring admissibility, remember, if I am recording something, I, as a civilian, I'm not thinking about whether it would be admissible or not. I'm recording it to take it to my lawyer to say that, look, these are the grounds upon which I want to do X, Y, or Z, file for divorce, it's infidelity, it's whatever it is. Whether it becomes admissible or not is beside the fact. The fact is that I would have committed an act, filming someone or installing a camera somewhere to monitor my own home, but in the bedroom or something like that, to capture an image of someone or that's engaging in something, my spouse and a strange spouse or whatever it is. So I think that I think we have to be careful. And my concern is that people feel emboldened that they are permitted to commit acts of voyeurism that could eventually lead to, or that would cause humiliation and distress, not necessarily sexual gratification, but that they are permitted to do so because it's in pursuance of some legal proceedings, contemplated legal proceedings. So that's the concern. So if you all would submit later on it, we'll be very grateful.
Angie?
Thank you very much.
Back on what Janji is saying, we need to explore. I understand what Jayanti is saying, but we need to explore. This may very well provide an exception for the private investigators who are engaged, especially where there are contentious proceedings in family law. These private investigators, they pursue their targets and they seek to capture images, video of spouses, engaged in certain acts. So just for the Law Association to consider that as well.
Right. Thank you very much, Member Mitchell. I was about to pass to you, so I would now invite Member Mitchell to take us through the submission from the Media Association, and thereafter we would engage the Trinidad and Tobago Promoters Association. So Member Mitchell, Media Association, and then the Promoters Association.
Thank you very much, Chair. I want to welcome the Media Association. Thank you for joining us. Also, I'd like to extend to the Media Association. There was an editorial on Sunday, and I want to, through you, thank the Express for bringing a spotlight to these proceedings and to these matters that we need to have ventilated, and we are indeed getting ventilated through these proceedings. I want to start off by asking the Media Association, with respect to Clause 5 of the bill, Section 22B, the proposed amendment to 22B1A. Does the Media Association accept that this section potentially affects adversely media photographers?
I'd like to just ask you to elucidate on that particular one, because like I said, I've just had my eyes dilated, but I could go over the Clause 5 so that hopefully that should...
We're in 22B1A.
Right.
It's a section that treats with the taking and sharing of an intimate image without consent.
Right. Right.
So,
oh, okay, I'm not muted. Let me just go over that a little bit, if you allow me. I think that also goes back to the way the media will interpret this is vastly different, I imagine, to other perspectives, and they're very valuable perspectives here. We actually have no problem with most of the amendments, and our real gray areas are in the area of photography. And I'm not sure that the amendments sufficiently catch photographers in the media so that, they can potentially, face prosecution based on the photographs that they take. So I'd like to actually go back a little bit more, if you'd permit me. we have suggested from clause 4 that the definition, the person in a manner or context that is sexual, needs a further clarification, right? Because, and that ties into greater clarification that's required regarding public and private spaces and the reasonable expectations of consent. So of course, you know, in the UK, the term, the upskirting and down blousing in public, where a camera is pointed at women unknown to her in a public and captures an intimate image, you know, where do you stand with that? Clearly, the law is on the side of, you know, the woman who feels violated. But I'm not sure that the law, that this covers that by its very nature. Most shots during Carnival, for instance, can be construed as upskirting or down blousing. I'm wary that our photographers are not sufficiently covered, even by the reasonable expectation clause. So, for instance, you know, you take a young woman, she may be somewhat drunk, and you know, a photograph is taken, and it could be you know, or she could be in the background. There's a certain sexual element to it, and it finds itself in the newspaper amidst all the din of Carnival. Where would the photographer stand there? You know, and you know, we've noted the defense for the purpose of obtaining sexual gratification for himself or another person, or causing humiliation or distress to a person that he knowingly has taken a particular photograph. How is the prosecution, and this comes back to my earlier point, going to prove the intention of the defendant? Should the onus be on the defendant to prove he did not have such an intention? And if you think about Carnival, it's a very, very particular festival. It's very particular to us. We understand it in a certain way. So, you know, let's say that, you know,
Before we move on any further, I think we get the point from the Media Association on that. And I just want to invite, because they've made submissions on intimate images, I want to invite the Trinidad and Tobago Promoters Association to make their submission on intimate images, and after that to invite the Center for Nonviolence to make their submission on intimate images.
Can I just finish my point? I just want to say that I think there needs to be a broader definition of public interest, especially when it comes to Carnival.
Yeah, so Mr. Chairman.
Thank you. Yeah, thank you. Can we invite the Trinidad and Tobago Promoters Association on the issue of intimate image, which is in their submission, and then the Center for Nonviolence on the issue of intimate image, which is in their submission.
Right. On that same note, we had a similar concern, and that's why we would have asked for a couple of things to be clarified, especially because of the nature of Carnival. Is that I saw the phrase, the word underwear used, and we would like that to be clearly defined, just to remove any kind of ambiguity at all, because a Carnival costume to some may be underwear. It may seem as underwear. The other thing for us was in terms of consent, and it's the same thing the Media Association will be alluding to, is that what we have seen in the past as well is that even in the case of like music videos, you would have people in an intimate setting where they're in a bedroom in underwear, and it's for the purpose of a music video. How do we deal with that? We have cases where people will give verbal consent, and that's why we ask for the clarification of consent to be defined as well. Would verbal consent stand up in court, or do we have to get people to sign something in situations like that? A lot of music videos, we do that. We do get them to sign something. But in the case of the average person giving verbal consent, how do we deal with something like that with images? The other phrase that we asked to be clarified was sexual gratification in the point of voyeurism, where if you have someone in a peeping Tom situation that is caught, and then you say, well, okay, you are a peeping Tom in terms of sexual gratification, and the person responds, well, no, it wasn't for sexual gratification, I was just looking. How do we treat with that as well?
Okay, thank you. And the Center for Nonviolence Research and Development on the issue of intimate images.
Our concern was, which was mentioned before, to amplify the meaning of the word consent, and also to consider professionals who their profession is taking pictures. And what does that look like and mean in the public sphere when you have a large number of individuals where professionals have to do their job? How are those professionals protected, and also how are the persons within that space protected from harm that may be used in a sort of concealed way to humiliate someone in that space? So for us, it's about, really looking at what that consent looks like and speaking to the point of sexual gratification. Have that kind of clarified for us.
Okay, and I believe that the submission from Feminitt TT also touches on intimate images. So I would ask Feminitt TT to make their submissions on that specific point, and then I would go back to Member Mitchell to continue with the Media Association.
Thank you, Chair. We were wondering if there could have been greater consideration taken for if tapes used in guest houses, monitoring people who come in and out. We don't know, well, I don't know where these cameras are placed. And so in a case like that, if it is to monitor criminal activity, but we know sometimes what the purpose of guest houses can be, how can that then be regulated? And the other point is for, and I heard that the member from the Promoter Association would have raised that too, to kind of expand what underwear means. Should it include swimwear also, take into consideration that there are also children who go to the beach, and then we don't know what kind of people that may be there and what their purposes are for taking those images, and also expanding consent. And just one quick point, in the case of noting that sometimes these images can be used for whatever intention, it's the onus then on the defendant to say, this is not my intention. Where does this leave the survivor? Is it survivor-centered? Is it possible that laws at all in this case can be survivor-centered? And would the images still be destroyed even after, let's say, the survivor loses the case? What happens to the images after?
Okay, thank you. And I just want to note that your submission did include a suggestion that the Children Act be amended to deal with the issue of swimwear in relation to children. So Member Mitchell?
Yeah, thank you, Chair. I will be brief now. I've heard what everyone has submitted. I simply wanted to get from the Media Association whether they accepted that the section with respect to taking and sharing images affected media photographers. And I take that answer to be yes, and I agree with that. I also take the submission of the Media Association with respect to the exception in the public interest may not specifically attach to media photographers in the course of their duties. So, Mr. Chairman, what I would suggest at this stage, I think that national security in their submissions provided a helpful suggestion of an amendment to the definition of private parts. And that reads, in the circumstances where the genitals, buttocks, or underwear would not otherwise be visible. And that would create exceptions in the case of Carnival, in the case of modeling, etc. So, Mr. Chairman, my suggestion would be send that proposed amendment from National Security to the Media Association, to the Trinidad and Tobago Promoters Association, and others for their comments on whether that amendment is indeed helpful to exculpate media photographers and professional photographers in the course of their duties. With respect to consent, we've received submissions that professional photographers do have an established standard and an established way of receiving that consent. And that is something that I accept. Thank you very much, Mr. Chair.
Thank you very much, Member Mitchell. Member Mitchell, apart from the sexual image, or the intimate image, the Promoters Association also raised the issue of material from previous relationships. Perhaps you can engage the Promoters Association on that aspect of their submission. And also images, I wasn't too clear on the submission on intimate photos where the offender downloads it from a WhatsApp group. So I think we could explore those two areas with the Promoters Association of Trinidad and Tobago.
Sure. So with respect to point 2 in your submission, Mr. Priscilla, you've asked for consideration to be given to intimate photos unintentionally downloaded from WhatsApp and stored on one's phone, and whether or not that would create an offense. Could you just expound a bit?
So what we would have seen happening in the advent of social media and with WhatsApp and these message sharing applications is that a lot of both men and women become part of groups. I'm sure a lot of us here are in WhatsApp groups ourselves, and someone may have private photos of anyone and they would share it in a group. Now, some of these settings on these phones for these apps may automatically download these things onto your phone. So if you are in possession of these images, what happens then? And then we think of the word intent. And if it's a case where your phone app, the app on the phone is not set to automatically download the images and you go ahead and download it on your own, what happens in a case like that? How do we treat with that?
Yeah, thank you very much, Mr. Priscilla. Actually, that is a point that was raised in the cybercrime bill. And now I understand, because you didn't specify where you have the setting of automatically add to your role. And I myself, sometimes when I have a lot of land documents, survey plans and so on in my role, and sometimes when I go to it, I'm shocked at what I see there, because I have automatic, and then I try to find out where it came from, because it came from a chat, hours ago. And yes, I now understand, and maybe if there are any other stakeholder before us who has that concern or that experience in relation to finding yourself with an image that you did not access or download or create, but it is there on your device, and what are your views on that? A very important point raised by the TNT Promoters Association. Any other stakeholder has a view on that?
May I speak? Okay, so in the media, across media, there's lots of WhatsApp groups, that editors have, and that those WhatsApp groups are used for news purposes, and reporters and photographers are part of those groups as well. So let's take a situation that has obtained in Trinidad maybe a couple of times, when, say, a mentally disturbed woman has removed her clothing in public and walked, say, amidst of traffic. And that image has been captured by a news photographer to be showed to an editor or passed on to a news chat. Now, or a mental health expert. Now, what happens if one reporter from there unknowingly downloads that photograph, or it just comes on their phone, and suddenly you have a position where a reporter has a photograph of a completely nude woman in the middle of traffic, in the middle of the street on a bright day. Where does that photographer stand, or where does that reporter stand on that? And indeed, I'm not very clear as to how the photographer and the media are covered in that kind of situation. How
Maybe I could ask Ms. Matthew a question also, based on what she's commenting on here.
Sure.
Ms. Matthew, this is something that came up in the cybercrime JSC many months ago, and there's consistent reference, and rightly so by yourself and other colleagues in the media, about exculpatory clauses for persons carrying out legitimate media function. In today's context of social media, blogs, cameras, phones are cameras, gathering content all the time, who or what is to be covered by the phrase a reporter, a media photographer, a media person, in the context of almost everyone could say, well, I was acting as a media person because I have a blog and I'm putting content out for consumption. And that has been a concern in terms of, we know what a reporter is and a journalist is in the general sense, but in the present context of technology and everyone having their own portals, how do we reconcile that?
And, you know, thanks for that, Mr. Richards, because that's something that the Media Association, we have been grappling with it and broadening our definition of what media is. I think we are in the process of doing that, but there are certain benchmarks by which it is very apparent whether that a photograph has been taken for lascivious reasons or simply to increase somebody's media profile, or whether they are, it's a legitimate part of their duty, as, you know, whether they are bloggers, because there's some, you know, bloggers who are very legitimate, who are doing great work and who are part of the whole media landscape. So I think the surrounding circumstances of the person who's taken the image, how they use that image, will all help us to come to a kind of decision whether they are legitimate or not. It's very, very different. It's, you know, it's no longer as simple as it used to be that this person is media and this person is not.
Who's a media practitioner, and with this also, the legislation seeks to criminalize taking the picture and or video, storing in some instances, and sharing. And what is your perspective on the, because many of these scenarios may intersect to the benefit of persons who wish to exploit them, unfortunately. And should there be some sort of clause that indicates you are storing for a particular reason, you have a particular time frame within which to delete the image if it comes to you inadvertently, or if you think the image crosses some sort of line, and also how does that reconcile, in your opinion, with how do we prove the person is using it for sexual gratification and not a legitimate person, or both?
And that's a question that we've been grappling with as well. So I found that the idea of public good can cover a lot of that. A Canadian definition of public good comes from a case currently before the Supreme Court. So the public good there means necessary or advantages to religion or morality, to the administration of justice, the pursuit of science, literature, or art, or other objects of general interest. I would like to suggest a definition that that first of all, you know, considers our cultural festivals, and second of all, also takes into account mental illness amidst, you know, you have people who are mentally ill, who have people on the streets who take their clothes off, take that into account. And also it should be so broad as to, yes, the image has been taken, but how has that publication actually used it? So the media definition definitely needs to be much broader than just having it in your possession and having the ability to share it.
I respectfully would like to make a comment on that, Mr. Chairman, if I may. I regretfully do not agree with the comments made by the last two speakers based on the contextual and the structure of Section 22A. It seems to me that it says very clearly, a person commits the offense of voyeurism for the purpose of obtaining sexual gratification for himself or another person, or causing humiliation or distress to a person where he knowingly, or the question is where he knowingly observes, whether without or with the use of equipment, a person doing something and he does not have the consent to being observed. So it's very much a very specific part of the legislation. I don't see it expanding into the public media. I do, however, I must tell you, I do agree with the concept of what is a journalist for the purposes of the law, because everybody is now a journalist. But quite clearly, the Section 22 is specific. A person must knowingly take a picture or a photograph or video image, and he must do that knowing or reasonably knowing that the person does not consent to being observed. So I think it's a little, the section itself is tight. I do, of course, agree that I have a public within the definition of public interest, because public interest is a morality compass. And we know as recently as a couple of months ago in Richards and the Attorney General and PSC and so on, it's a very nebulous sort of thing. So I agree that they need to tighten the definition of public interest. And I also would like to suggest that we perhaps don't follow the Canadian over-regulated scheme. That's a matter for perhaps written comments.
Thank you. Thank you very much, Mr. Rajkumar. Before you take us all to the courthouse, I want to go back to Member Mitchell on the third point, which was raised by the Promoters Association on the issue of a previous relationship material and how that is dealt with. Member Mitchell?
Thank you very much. Let me just say that I agree with counsel. But Mr. Priscilla, the other point that you touched on was a point that was very live in the debate on the second reading of this bill. The point of that court matter between Lendell Simmons and Therese Ho. And it treats with the storing of intimate photos, images, videos from a previous relationship, despite the person asking for it to be deleted. Could you just explain your points in terms of what social mischief you see there?
So what we would see happening is that, and that's where consent comes in as well, is that while you're in a relationship with someone, they would give consent to have pictures of themselves taken or videos of sexual acts being committed, and it's all fine and good while you're all together. And then the relationship ends and someone moves on, and then what happens if the person calls and says, please remove the images or the videos that we took? What happens in a case like that? And you're caught in possession with it still, and you have no proof now. And again, it goes back to consent is my word against yours in terms of if you have no recording of that conversation or no written proof of saying remove the images, there was consent given at the moment when the images were taken. But does the consent, is that removed now when you all break up? If you are found in possession of an ex-girlfriend or boyfriend or husband or wife's images in your possession, how does the law treat with that?
Yeah, so that touches on the matter of voyeurism and not on the taking and sharing or on the sharing point. So we'd look at it, we'd look and see whether the storing of those photos where the person has now retreated or removed their consent for the photos to be stored, and the person still remains in possession of those photos for their sexual gratification, whether they are indeed caught. So let me thank you for your submission, for your observations on this. They have been quite helpful.
Thank you very much, Member Mitchell. Thank you. I want to now move to my colleague, Senate Member Renuka Sagram Singh Suklal, and in particular the submission from Feminitt TT. Now, Feminitt TT has, Caribbean, sorry, has given us six recommendations. I would say so far we've addressed the issue of swimwear, which is recommendation number 6. The first recommendation deals with gender inclusive language, and it is a submission that has been made by several of the stakeholders who are before us today. So we note that one. I wouldn't ask you to explore that first submission. The second one deals with the security monitoring. We've had some discussions on that already. The third deals with the issue of intimate images and the issue of consent. We've just talked about that. And then fourth and fifth deals with areas that I think we need to explore now, which would be the use of the expression reasonable, which has given several stakeholders some challenges. And the second deals with the use of the expression private parts. So Member Sagram Singh Suklal, I wish to invite you to engage Feminitt Caribbean on the fourth.
Thank you.
Yes, we are. Proceed.
Yes, thanks. So on the point, so Feminitt TT, Caribbean, sorry, in your submissions, you would have suggested that further steps should be taken to define jargon in the bill that appears unclear, right? A specific reference was made to the term unreasonable. If for the benefit of the committee, you could just further clarify your concerns with the use of that term reasonable, identify to the committee specifically. Is it just that your concern is just you believe that this perhaps there's a necessity for us to define the term in the bill? I just want to solicit from you your concerns relative. Is it just is it that you would prefer to see placed in the bill a definition of that term reasonable? Maybe we could just get into that a bit.
Yeah, thank you so much for the question. Most definitely, because we know sometimes some words can be quite relative. And so we don't want to leave any loopholes for misunderstanding. So I think it is important for that to be clearly defined, or maybe use another word that can really help people understand what it means. So yes, it's just based on definition.
Okay, now are there any other, so of course you would have had the opportunity to go through the entire bill, right? Are there any other, on that point of not being clear of specific terms, after considering the amendments or the bill that appears before you, are there any other terms that you may have difficulty with that you would probably want the committee to also consider? And of course, take a decision relative to whether it's necessary for us to, have a definition of said terms in the bill. Any other terms that you may want to point to us to?
Yeah, so we would have previously suggested defining what consent looks like, what that means, as well as, sexual gratification. And I think there is, and then of course, private parts with exploring, which is in point 5, what are private parts? Because we know sometimes that would have been a word that we heard growing up, which doesn't give us the language to really understand what are we really talking about. Because I can say my private part's my elbow, but
Right.
that may not be considered a private part when you think about it.
Okay, so point is duly noted, right? Now I want to go on to survivor-centered approach, and I just want to be able to solicit from you and from the entity, what is your understanding or your definition of this survivor-centered approach?
Yeah, so it takes into consideration the needs of the survivor first, which I think with the questions that were asked earlier and listening to the contributions from other stakeholders, we were wondering, now I guess it's easier to kind of expand on, because it seems as though when it comes to criminal acts, it's up to the defendant to say that this was not my intention. But if the survivor is stating that this caused me harm, yet your intention may not have been to cause me harm, but the impact did do that, how do we then deal with the issue? And I think and I guess it happens with most legislations where it doesn't consider what happens to the survivor after after the case ends. Would the image be destroyed, even if they still are uncomfortable and they have to live with that for the rest of their lives? What does that look like? So for us, it really looks at taking into consideration the survivors, what they have gone through, and how can we assist them in the greater scheme of everything.
Okay, so excellent. So with respect to this survivor-centered approach, right? Is it that you're recommending that perhaps this be incorporated into, let's say, a clause or provision in the bill that appears before us?
Yes, most definitely.
Okay, then, Chair, I think because the substance of your submission, you were already to make that submission on security monitoring and so on. Chair, that is the extent of my questions.
Okay,
If I could make a comment very quickly. I do know lawyers like to talk a little too much, and I'll keep it very brief.
I was about to say to you, I hope you don't send us a bill. Lawyers like to talk and bill. Proceed, Mr. Rajkumar.
Pro bono, but I will explain to my friends in the committee and everyone that reasonable person is a concept well known to law. It exists going way back to the 1920s and has been defined as a number of occasions as a reasonable person being the person who is normal in society. So I don't know if you need to have that further defined. It's a concept that is well applied in civil and criminal law. So it's a matter for the courts to determine, having regard to all the facts and all the circumstances, whether or not the conduct was reasonable, as the man, as we say, as the man down at the Brian Laura Promenade would think it so to be. So it's a concept that we have worked on, that she is well aware and has applied on a number of occasions. Consent is also defined very clearly in the Sexual Offences Act as to what consent is made. I do agree, however, that sexual gratification is something that could mean just about anything and perhaps needs tightening up. With the question of victim survival, we do require now victim impact statements to be made available by the prosecution. So that may help you, and perhaps you could put in that any images that are offensive could be destroyed, very same way we destroy exhibits when they are illegal. Perhaps that could help.
Thank you very much, Mr. Rajkumar, and thank you very much for admitting that sexual gratification, not only the definition of sexual gratification, but the proof and the proof of intention is in my submission in the debate. I pointed out that is going to prove to be a hurdle for prosecution. I want to now go to the submission from the Center for Nonviolence Research and Development. I want to point out that the center has made about 8 recommendations. We have dealt with the definition in relation. They've raised the private parts and reasonableness as issues which we have addressed. The issue of consent, in particular forced and coercive consent, and that is something you could engage us on. The center has also raised gender neutral legislation, and I've indicated we've had submissions on that already. And we've also been talking about the security monitoring aspect. I want to ask my colleague, Senator Paul Richards, to now lead us off on the submission from the Center for Nonviolence Research and Development.
Thank you, Chairman. If we could go for the representatives for the Center for Nonviolence Research and Development, as the Chairman guided, we've had quite a bit of discussion on intimate parts and reasonableness. Give us a sense of your forced or coercive consent, and I'm quoting from your submission, which is quite extensive, quote, which can occur using primary and secondary threats, coercion, punitive measures, and intimidation. Also consideration for when a person gives initial consent or free will and in the right frame of mind to be observed, recorded, photographed, and subsequently changes their mind from being observed, recorded, or photographed during the sexual act. So is the intention here the person who is the subject of the recording changing their mind and having the right to change their mind during the sexual act or sometime after? If you could clarify that for us, please.
An individual have the right to change their mind or revoke consent during the act and subsequently. And our issue in relating to force or coercive consent is where an individual uses any type of information about the person or their presence in a particular environment to coerce that person to participate in an act against their will. And I'm bringing this example. During this present period where COVID-19 is undermining so many issues and lives, and also amplifying and exacerbating the same within our society. We have had individuals whose landlords have said to them, because they have lost their jobs or have received reduced employment, have said to them that it's either they go on the street right away or they participate in some type of sexual act. In those moments, we have had women say to us, and men also, that when they look at, we have children, our families are unable to take us in, some of them consented in a coercive way because the threat of being homeless was used against them in that manner.
So is it that you think that, because we brought this up with the Ministry of Social Development and Family Services, where I think I brought the point up about persons who are in vulnerable situations, who because of the circumstance at that point may not necessarily have the normal agency that you would have if you were not in that situation, and so the person exploits that. Do you think there should be some sort of reference that in the bill that persons who are exploited in vulnerable situations and may give consent under those conditions may be considered, their complaints or their charges may be considered valid, even though the person may say, well, they've signed off something or they've given them verbal consent or something like that? Is that what you're suggesting?
Yeah, to a point, the term vulnerable, I'm not a legal mind, I'm in that process, but however, the term vulnerable to an attorney may mean many things, and it may be problematic to prove in some instances where there isn't sufficient proof and evidence. But for us, we believe that some type of wording ought to be included in the amendment that prevents and protects a victim in cases of coercive attacks and acts of violence.
Okay, your other part 6 of your submission also deals with law enforcement and possible abuses of power. Would you care to elaborate on that a bit, please?
Yep, our challenge with that was that law enforcement and other professionals who observe, take pictures and so forth are exempted from punishment and any type of legal recourse. And we have law enforcement agents and other professionals who may use their authority to commit acts against a person's body that violates aspects of this bill. And what measures can be put in place to protect a victim from further harm and protect someone from potential harm. And again, I am speaking from experience where we have had women who have gone to make reports. And when I say woman here, please don't think if I exclude men, but the women are in the majority. Women who have gone to make reports, and again, they are coerced or were coerced by law enforcement officers. We have law enforcement officers who have used their authority and position to abuse their spouses within a relationship and even former partners. So how do we put a line, and what type of framework can be implemented within public and private places of employment that protects individuals from further harm or potential harm?
I wonder if, Mr. Chairman, you permit me a comment. I know I'm interrupted. Could I perhaps suggest, first of all, the law provides in the Interpretation Act where you use the male or the feminine, it refers to both or any kind of sex. So it's not where, even if you use in a section he, it means she, or, well, I know things are changing now. So that should help you there. The second thing is consent must be free. In other words, it cannot be tainted by any sort of threat, any sort of fraud, any sort of misrepresentation. If a person is subject to sex in return for staying in your house, that's rape. Make the report. The Act also makes it very clear, performed by...
Mr. Rajkumar, could you, since you're giving a legal overview, could you give us a sense, based on what Ms. Alexander Benjamin has indicated in terms of persons who may be, with the definition of vulnerable, that the person may be in some way incapacitated by their circumstance? Is that something that the law covers
yes,
for?
that in itself, because it means that the person hasn't got the free will to consent. And the consent must be with free will. For example, you have instances where men arrive at the house and say they're their husband. That's rape. Even though she may have said yes, and when she realizes it's not the husband, it's rape. Or consents to some sort of medical procedure to find out, no, it was not a medical procedure, it was an excuse to have sex. That is not free. That is not proper consent in the law. So you have to look at proper consent. If a landlord is going around the place and saying, well, I want sex for you to live in my house, go to the police and make the report. That's rape. That's a very unfortunate position.
Well, that may be the theoretical right thing to do, but the person under those circumstances may not feel they have a choice in the matter because they are fearful of being put in the street with their children and their belongings. So just to say, go to the police and make a report, to me is not encompassing
I disagree with you, because even if you put that in the legislation here, it still means go to the police and make a report.
But you may not agree with
investigate
me,
and prosecute
but it is a valid perspective that the organization is proffering and that people have experienced and are experiencing. So go to the police and make a report. It should not be the only consideration.
Before I invite Member Lakshmi Diyal, let me just ask the center, Ms. Alexander Benjamin, just to discuss. You've made a very interesting submission on requesting that we include what you describe as the pornography clause. So I'm just going to ask you to quickly indicate, what your thinking is behind this, and then I'll invite Member Lakshmi Diyal.
Very quickly, if I would say that one of the things that we also ask for is, as we progress as a society, is the humanization of public policies and laws. Theoretically, it's very good for an attorney to sit and say, go to the police. And that is a right action and step to take. Humanly, when someone is violated and their agency and their autonomy has been stripped for that moment of violence against their bodies without their consent, whether that lack of consent is due to coercion or through the physical act, it places that person in an incapacitated space for a period. And we also have to consider other extenuating factors. So we may say, go to the police. And this is one of the other things that we also ask for, the education and training, not just for law enforcement or officers, but for society as a whole. To the point of pornography, we understand that there are other types of measures and accents and clauses in other bills that may speak to pornography. In this instance, we also look at, again, in that coercive frame. And when I speak here, I'm also speaking as a intentionally progressive survivor of severe sexual assault and also childhood abuse. So I'm bringing that to this space here today. So I'm not just speaking as a professional, as an advocate for the rights and of human beings and the prevention of violence. In terms of let me just get the point here for pornography clause, again, going back to that aspect of force or coercive consent, where a person is forced to view those images within that space they are in and with whomever they are with. So that's just a summary of it.
Thank you very much, Ms. Alexander Benjamin, and I want to thank you for your submission. And sometimes the best submissions we could get are from persons like yourself who are survivors, and we appreciate what you've shared with us. I want to go to Member Lakshmi Diyal.
Thanks, Chair. Just a quick comment. I think we're getting a lot of material here that deals with the social side of this problem. And I just want to make the point, though, that you can't legislate for every circumstance and every social issue. And a lot of what has been raised there are really good comments, but it goes to implementation. Nobody will say it more than me that laws are just words printed on paper, and it's the implementation. So it's how you deal with that issue of consent, where it's coerced and you're acting under duress, and education and training and all of those things. They are very serious issues pertinent here, but we can't necessarily legislate sometimes for those things. So focusing, I mean, what we really do want to focus on here would be how do we capture the offences, whether or not the exemptions are too broad or too narrow. And I think the media has a lot of, and photographers and so on would have a perspective on that. And we also have to look at how we balance rights. We have a lot of issues here in balancing. You have to balance the rights of the homeowner to monitor versus the rights of privacy of a guest or an employee. You have to balance the right of the media to publish certain things versus the right that people have to expectations of privacy, depending on how they're dressed and so on, and living, caring about themselves in public. And we have to balance, somebody raised it, law enforcement. And I just want to make the comment as well that once something is not done pursuant to illegitimate, part of the job, then they do not fall under the exemption. That's my understanding of it. But a law on paper is also subject to interpretation by the court based on the factual matrix that presents itself. And nobody, we could sit here and talk from now till thy kingdom come. We cannot contemplate every factual matrix that will present itself from the court, and that's why we have the court. So a lot of what we are dealing with, it simply can't really find its way into legislation, but it's a matter of implementation. But it's good things to take note of in terms of the powers that be having to roll these laws out and how they train officers to deal with reports and so on going forward. So I just want to make that comment so that everybody, I don't want anybody to feel that their comments aren't being taken on board. It's just it may not find itself into the actual words that you eventually see in a bill.
Thank you very much. I want to go back to Senator Member Richards, and after Member Richards, I would invite the other members of the committee to ask any or make any further submissions they would like to make, and then I would go to the 6 groups that are before us and invite them to make their closing submissions. So Member Richards first, and then I would ask the other members of the committee if they have any other questions, ask any of the stakeholders.
Submissions for the group. So unless the group has a closing comment, a brief closing comment, I'm fine, thank you.
Right, thank you. Member Mitchell, Member Sagram Singh, anything further from you?
Further submission.
No further submissions.
Right, thank you very much. I want to now go invite the stakeholders. You've been, as Member Lakshmi Diyal has pointed out, you've made a lot of submissions, both in writing and before us today. Strictly legal submissions. I want to say that a lot of social issues in the country, in particular, I'll use the example of the pervasiveness of drug use in the 1990s, for example, were addressed by the law, by the introduction of strict liability offences and by the introduction of harsh penalties. And there is a way in which the law can address social issues, but of course, as Member Lakshmi Diyal rightly said, a lot depends on the implementation. So I want to invite first the Media Association to make your closing comments.
I think I've said most of what I wanted to say earlier, but there's a lot of merit in actually defining certain wordings of the law, such as reasonable expectation and public good, especially when it comes to photography and especially during Carnival, where I think that this law will mostly apply. I am worried that our photographers, that it's not broad enough to cover, what our photographers do. And similarly, I think I think one of the gentlemen brought up the whole question of what is a reasonable person, and I think that whole thing kind of changes during Carnival, where those the rules that we apply in the everyday context of our lives don't actually apply during a national festival, where we kind of understand, what the rules of engagement are. For instance, a woman does not expect a man who she doesn't know to come and wind up against her in a bank. However, in the middle of a Juve, situation where everybody is drunk and it's twilight, it's entirely different. So I do think that those definitions definitely need to be broadened, especially in terms of photography, and once again in terms of mental health. When our photographers capture whether nude people or people walking on the street, and they have it on their cameras, they pass it on to mental health professionals, other media and their editors, I feel that they ought to be protected. I don't think that this particular amendment protects media sufficiently, and particularly does not protect our reporters. And the final point is that people say that, the taking an image knowingly. If you're actually covering a carnival, I think Mr. Richards will understand, is unwitting, because it happens very quickly. What if, you've covered something, it goes live, and there's something that's happening in the background? So does that put our photographers and media, immediately in the wrong? So those are some of my closing submissions.
You have authorization from the bodies to cover it as a media house.
Yes, we do have authorization, but if there's something that, then once again, that's why I would like, the definitions to be a lot clearer in terms of public good in a carnival setting as versus public good, when we are going about our everyday activities, reasonable expectations in a non-carnival state, in a state where you don't, that is what we do. We mirror society. So if we find there is a woman who's naked and perhaps it's not done, tastefully, what happens to our photographer, especially if he does not have the intent that is presumed in the law when taking photographs of a nude person or somebody who is indulged, or in acts like that. And similarly, once again, reporters and journalists, we cover rings of pornography rings, child pornography rings. What happens then if a reporter captures something like that? Where does the photographer stand there? So I don't feel that there's sufficient, that the law is wide enough to catch the whole aspect of media photography, and it probably should be broadened both in its definition and perhaps in terms of the wording, extra wording.
Thank you very much. I invite the Law Association.
Thank you very much, Mr. Chairman. In addition to what we have stated in our written comments, which we adopt with everything, may I suggest that I take on board the submissions of Ms. Alexander Benjamin. I'm not sure if this is the correct act in which you should create proper education to the protective forces as to how they deal with victims of sexual abuse, but I think it's a very good idea. And I think that there's some way it should be brought into the forefront of when we are dealing with persons who are victims. Save as I said, unless there's anything else you wish me to comment on.
Thank you very much, Mr. Rajkumar. On behalf of the Law Association, I now invite Feminitt Caribbean.
Just thank you so much for this opportunity today. Just like in our written contribution, we just want to make sure and amplify and always have to the forefront that there are conventions that we would have signed and ratified as a country. And I think even though we can't legislate for everything, I think it's important for us to figure out how can we stay true to these conventions, because it does take into consideration human rights and how we can protect people. And I think this is very important to have consultations with stakeholders, and I hope it's continue moving forward, even though I know it's a process that's already in place. So thank you again.
Thank you very much. Trinidad and Tobago Promoters Association.
First of all, we want to say thanks for including us in this discussion. We think it was a very vital discussion to be had in terms of all the points raised. One thing we would want to keep reiterating is that we are in the age of technology, so we have to make sure to cater for these things, especially in the fact that a lot of the law alluded to the sharing of the pictures, but we also had to take into consideration the receiving and the possession of these pictures as well, or these videos, because I know in terms of the ammunition and with the drugs, if you're found in possession of these things, you are liable whether you know it or not. And I just think we need to be careful with that in terms of the people who receive them, as Chairman would have said himself, in terms of not knowing that you are in possession. How do we treat with some of those items? Well, thank you very much for having us here.
Thank you very much. I invite the Center for Nonviolence Research and Development, Ms. Alexander Benjamin.
Thank you very much for having us and for participatory engagement. And added to everything that was said, I would just like to say that laws may work to regulate behaviors, but not the conscience. And that is something that we live with in our society. However, a country's progress is seen in the way it protects its citizens through its laws and development and strategies, because these are some of the items that determines its progress. We understand that violence in all its forms can be used to manipulate unequal power relations, to inflict imaginable harm against others, using it as an act of vengeance, intimidation, coercion, humiliation, to punish. And all that happens in the context of things we call culture, socialization, education, and now with the rapid exchange of technology. So added to everything that was said, we would like to see a law that perpetuates the prevention of violence in this context, which is sexual misconduct against people within society, that reduces unequal power relations and hold people to account for their crimes against another individual, but also work to protect the survivor, which goes to Feminitt Caribbean's point of having survivor-focused and trauma-informed policies across the board and across all phases. Thank you all.
Thank you very much. And as always, I always ask Ms. Diana Mahabir-Wyatt to have the last say.
Thank you, Mr. Chairman. I was very impressed by the points made by the Law Association, and I am very appreciative of those. We have already made our comments in writing. I don't have anything more to add to those. The one question that I want to ask, which I always ask and I've never had an answer for, is how do you prove a negative? How do you prove that you don't have the intention of? And that has come up with several speakers this morning, and it's almost impossible to do. How do I prove I didn't have the intention of getting sexual gratification out of an image or a statement? I know you don't have an answer, but I just like to leave you with a question. Thank you very much, Mr. Chairman. I've enjoyed the morning.
Thank you very much. I want to close by thanking all of you for your written submissions and for attending and providing us with your views. You still have the opportunity to provide us with further written submissions based on the discussions today. I want to thank the AG's team, the Honorable Attorney General's team. I want to let you know that he's been following, and I want to thank his team, the Honorable AG himself, and the officers from the Criminal Justice Unit and the Law Reform Commission. I want to thank, of course, our staff here at the Parliament, the Secretariat, which supports us, the IT, and other people who help us in the broadcast. This meeting, as I said at the start, is live on ParlView and would be rebroadcast on the Parliament channel later today. And I want to thank, of course, the viewing and listening audience, live, those who have followed live and those who would view and listen to the rebroadcast later today. So thank you very much for being part of this session today. This meeting is now adjourned.
Thank you, Chair. Thank you, everyone.
Thank you, everyone. Have a good day.
Thank you, everyone.
Thank you, everyone. Have a good day and be safe.